Hello, this is attorney Marc Lopez, and I am so happy today to interview my very good friend, Jaimie Cairns.
Hi, Marc.
Jaimie is with the law firm Cairns and Rabiola, and they are an amazing family law firm, and I trust them with my clients and regularly give them referrals, and I'm so happy that she agreed to come over here today.
Thanks for having me. I thought it was great to do something with you since we regularly refer our clients to you as well when they're in a little bit of a pickle.
I can't even hold back my enthusiasm. So, I'm just going to jump into this, and so what I want to talk to you about is how criminal charges can impact the family law case.
Sure.
And so, the very first thing that I thought about is protective orders. So give me your thoughts on...
Protective orders, they're such an interesting beast. So I think often, unfortunately, they're used as a sword, so that if someone's angry at the beginning of a divorce, we see it a lot where they'll go file a protective order. A lot of times they do it because they want to get someone kicked out of the house without going the full legal route through the divorce. Protective orders in and of themselves, as you know, aren't criminal actions. They're actually in a civil court. And if you have an underlying civil action, they will often get bundled in with that civil action, so the same judge hears all of those things. But they can be a real pain in the butt to deal with because people can lose parenting time without a hearing. With protective orders, they have what are called ex parte orders, where the judge can issue an order based on a written pleading that someone files, which, as you and I know as lawyers, is kind of crazy. Like, that's not, usually can't get relief that way in the judicial system. So it is a problematic thing because it has such an impact on people really quick and without quick recourse that the people want.
And one of the things that I've seen as a criminal attorney, people call all the time protective order case, and it seems like a lot of people decide they're going to try to either not deal with the protective order and just let it happen. And regularly, if they have a family law case, please call your family law attorney. And just like she said, they will get those in there together. And protective orders are absolutely insane. Like she said, you can start doing orders for parenting time and also where you can live and other crazy things in protective orders. So do not ignore protective order.
Yeah, they can even address finances. It doesn't happen a lot, but on the application for a protective order, it actually talks about people that can ask for financial relief. So if you don't do anything with it, I mean, the court could theoretically say you have to pay the mortgage and the utilities and not live there. So be careful.
I'm smiling only because it sounds just ridiculous, but that's why I don't do that stuff. The second part is one of the things that we regularly deal with on my side, the criminal side, is domestic violence. So just from a family law perspective, how does allegations of domestic violence impact a family law case?
You know, frankly, it's not something we see a lot, and I don't know why that is. I mean, there's obviously a domestic violence problem in this country. I don't want to say that it's not an issue, but it's awkward because it comes up in situations where there are, criminal charges, and frankly, those people, I don't see them a lot. I haven't dealt with a lot of people that have underlying criminal charges for domestic violence, but if there are domestic violence charges, there's usually a no contact order, which you know, and a no contact order, unlike a protective order, is I don't want to say much bigger deal, but it is a bigger deal. There are much more stringent penalties for violating a no contact order than a protective order. So a lot of times with the cases that we deal with domestic violence have no contact orders, and then that again becomes a problem with parenting time and things like that. But domestic violence is taken very seriously in Indiana Code regarding child custody. It's one of the factors the court has to consider whether there's a history of domestic violence. So it's not something that the court will ignore, but it can be really problematic with proof. Have people called the police in the past? Is there a long history of it? Have they gone to the hospital? And oftentimes, unfortunately, domestic violence victims are hiding it. They're hiding it from everyone, and so they might not have done all of those things. And so it can get really. It's really sad because a lot of times you have someone that you really do believe is a victim of domestic violence, and they can't prove it. On the flip side, it's also really sad when you have someone who's being accused of domestic violence and they can't prove they didn't do it either. Yeah. So it can be a real proof problem. I will say if someone is a victim of domestic violence, they need to be doing what they can to document it while it's happening at the very least. If they can,
So what Jaimie's talking about, people that are victims and trying to use that, hey, a kid shouldn't hang out with a person that abuses me so much. You're absolutely right. People hide that so often. Mm-hmm. Even thought about that perspective.
Yeah, they hide it. They hide it. They hide it because you may know this and maybe you don't, but if there's domestic violence going on in a house, if it's one parent doing domestic violence and one not doing it, the children can be taken away from both parents. Because it's neglect to let a child see domestic violence, and I don't do any DCS work, but I know from the work I do that a victim can be further victimized almost because DCS can take the children away. So they have even more of an incentive not to let it become public information, even if the child isn't even a victim.
Yeah, that's reverse incentives, and that's something that people have to deal with. And from my perspective, defending against charges of domestic violence, I love it when there's an open family law case because I use that as a source of bias and to try to say, well, they're trying to get this because of, the family law to try and get a better outcome or determination.
Sure.
That's just something I get to do as a defense attorney. And I have also seen in the past where people have used going through messy divorces and they've used the police. And it's not how it's designed to use. And like you said, it's terrible when that happens because little kids typically are the ones caught in the middle.
Right. Well, and I've seen it where, if you are being hurt, just call the police. Like, undoubtedly call the police. But I often have family law cases where any dispute, they call the police. Like, verbal disputes. And they're like, I called the police. And I'm like, why? Like, because in a family law case, and as you know, the police report isn't admissible in and of itself. You've got to call the police officer. And the police officer's not going to remember a domestic run from 6 months from now by the time.
And even if he did, he wasn't there to watch the argument.
Yeah. So, people do call the police too much on that front. But I say call the police, certainly with physical violence. But it's not the most helpful thing to do all the time for no reason, certainly. And it's not a good documenter. People think it's like, I documented it. No, you didn't document anything.
Well, just in regards to the no contact order and the protective order, we see a lot of people with cases that are amazing to defend because you violate no protective order, you violate no contact order, it's an invasion of privacy charge, it's a misdemeanor, keep going up. And those cases, I love them at first because typically it's really hard to prove you did X, Y, and Z, but text messages, people just cannot stop sending texts. And how are you using those in family law cases, like these incriminating type texts?
Oh my gosh, we use text messages all the time. I just thought
pretty easy to get in too.
Yeah,
right?
Pretty easy to get in. I just used one last week favorably. The thing about text messages with protective orders though is protective orders they don't follow a form, which sounds funny because the order comes from a form, and you've seen them, I'm sure. But the court can pick whatever they want from the form, and then they can add sentences. I have a case where it says that the respondent, the person that the protective order is against, can contact the other parent about the children. Well, who's drawing that line? Yeah. And if the other parent's starting that contact, like it's really tough advice to say to that person because you have to be able to communicate with your co-parent unless you have an alternative way to do it. Yeah. So it's an issue that we face every day. I'm knee deep in one right now with a protective order and 50-50 custody. Like,
how are you not going to communicate?
Yeah.
And text messages now. Yeah. So we kind of talked about domestic violence, but there's other crimes. What other crimes do you see that are impacting family law cases?
All cases any criminal case can hurt a family law case. If you've got someone that you're fighting with you're basically fighting about your character. Yeah. If you're talking about kids. It doesn't matter if you're in a divorce without children. To by and large, a criminal case isn't going to affect much at all. But when you've got kids, it's a free-for-all. Everything matters.
So domestic violence is one of the factors they must consider. But there's also best interest of the child, which kind of get anything else too, am I right?
Absolutely. Best interest of the child can incorporate anything. And mental health of the parties is another one of the statutory things they have to consider. But it's a free-for-all. There's like 8 factors that are listed, and the last one's like anything that can affect the best interest. So, they really can consider anything they want. And I think with criminal charges, some stuff doesn't matter. Like I think that there's a reasonableness that the court isn't going to care if you've forged a check or something like that. Although that goes to the truth of, how truthful you are. So that's why I say it all matters. But, crimes with victims matter more. If you're going to hit someone.
But better not your family.
Better not your family. Okay. Sure, better not your family.
Give me. I know there's no such thing as a typical, but give me. Someone has drug charges in their past. What are some things that you've seen judges do to make the other party feel a little more comfortable about giving the person parenting time?
Well, so it's really matters. What really matters is when it happened. Okay. So I think I've had cases where someone has a drug charge that's 15 years ago, and then they had a kid with a person, and then that person now wants to bring up the drug charges. Well, that's not relevant. Like, you had a kid with them after they had drug charges. So
you knew about it.
You trusted them for a while. So it kind of depends on, it definitely depends on when the crime happened. Or the alleged crime, if it's still pending. I don't think, I'm stuttering because there's no two cases. Yeah, there's no two cases. I don't think judges handle anything in a typical fashion with regard to criminal cases. The reality of family law too is we don't see a courtroom as much as probably you do. Most things settle. So most of the time it's really worked out between the attorneys, like what can make the other side feel comfortable with the criminal charges.
So that is an issue, what you guys can negotiate on a resolution for that.
Exactly.
That's amazing.
It's nice. I don't mind the courtroom at all. I mean, it's part of our gig, but I don't see it nearly as much as you do, I'm sure.
Well, that's amazing.
Yeah.
Tell me anything else, how you think criminal stuff can affect family law, anything else people should know. Presumably if they're watching this video, they probably either have family law cases and criminal stuff going on or vice versa. So.
Sure. Well, I think that, it's important to hire a good criminal attorney. You know that when I have a case that involves a criminal matter, the first thing I do is call you.
Thank you.
But I think because the biggest fear I have, because I've had it happen in cases before, is that a criminal charge gets filed while there is a pending action, or even an old action where they're in a custody situation now after the divorce, and they admit to it, or they enter a plea agreement because they have bad counsel, and then that can affect the family law case. So make sure you have a good counsel, and then make sure if you have an open custody case that you give your permission to your criminal attorney and your family law attorney to talk if it's necessary, because you really want them on the same page about what they're saying in the criminal case or what they're saying in the family law case, because they can have an impact on each other.
And so one of the things that you enjoy when you're charged criminally, one of the only things you enjoy, you cannot be forced to testify against yourself. And so oftentimes we'll have issues where we have to go in front of a hearing, and it's awesome in criminal cases, you don't have to testify, but then you'll have prosecutors go into the family law cases and try to bring the testimony of the person from the family law case. So while they're separate actions, they can get mixed up. And so number one, you want to make sure your criminal attorney and family law attorney are friends.
Sure.
On a friendly basis.
Yeah.
And number two, you want to make sure you listen to both of them. And then if there's an issue that comes up, they can talk and figure out what's in your best interest. But yeah, that's always sneaky when someone's trying to pull in the family law stuff. I'm always like,
Right.
And I appreciate you looking out for my clients, and I'll always look out for yours too.
Yeah.
One of the things that my firm deals with a lot is people accused of drunk driving. How will a charge of drunk driving or even a conviction of drunk driving affect the family law case?
Again, it kind of goes back to what I said earlier about relevancy. Is it happening now? Did it happen a long time ago? Drunk driving is definitely one of the most common crimes we see in family law cases. I'm sure you know it's probably the most common crime for anybody to be charged with. So if it happens currently, the question is the person an alcoholic, and do they need treatment for their alcoholism? So I would say in my experience, a drunk driving charge isn't an end-all be-all by any stretch of the imagination. There are some things we would usually tell the client to do to make sure that they can prove to the family court that they're not an alcoholic, or that they're doing things to ensure their safety or their children's safety. And I know from my past experience that you give my clients great advice about what to do. It helps me in my family law cases.
That's what I was going to ask. There's a lot of things overlap. So things that we would have a person do, regardless if we're going to go to trial or not, to make them the best possible situation they can be in, will help out family law cases.
Absolutely.
And, you kill two birds with one stone. That's what you always want to do, save some money while doing it. So
yeah.
Again, there's no two cases the same. It's kind of what parties can agree upon. What are anything weird you've seen parties agree to?
I mean, you can agree to keeping a breathalyzer in your car longer. I've had a case where the clients agreed that that they would videotape themselves taking a breathalyzer before they had parenting time, and then shoot the video off to the other parent. Whatever you can do to make the other parent realize that you're not drinking and you're not doing anything inappropriate. Technology these days makes that a lot easier than it's ever been. We can shoot video. You could Skype. You could FaceTime as you're breathalyzing. Sounds terrible to watch to me, but if your ex-spouse or future ex-spouse is really that nervous about you being drunk, then the best thing you can do is take away any reason that they, take away that concern.
And I will tell you this, driving drunk in a car is not a fun thing, and it's get you in trouble. Driving drunk with kids in the car is a felony. Don't do that. And certainly don't send a video of your spouse doing that, or your ex-spouse with the kids in the back seat. That's not a good idea. But don't drive drunk with kids in the car.
Yeah, absolutely.
Jaimie, what is the best way for someone to reach out and contact you?
The best way is through my website or our phone number. So our website is www.crfamilylegal.com. and our phone number is 317-632-4711. We do offer free 30-minute phone consults. No questions asked. Do them all the time, every day. So.
And give me your geographic locations. How far?
Oh, that's a good question. We're located in Broad Ripple, just south of Broad Ripple Avenue on College Avenue. So, hot spot for
Heck yeah.
Indianapolis. We love it. Little house, not a big scary building, free parking. You need some money.
Something our clients don't enjoy. Any questions about criminal family law? Please call Attorney Cairns. Criminal law, call myself, Marc Lopez, 317-632-3642. Thank you so much.